Dr. Martin?
Morning, can you hear me?
Yes.
Okay, let me try to share this. This is always like my anxiety before these things. So let me try to share my screen with you. Let's see. No, be this one. Did that work?
Yes, it does.
Oh, okay, good. Off to a good
They're also
start.
different. WebEx, all those they're also different.
I know I'm a Zoom girl mostly, but you know, my husband actually works for Cisco, which is the company for WebEx, and I'm like, I dislike this system more than all of them.
Dr. Roden, do you prefer that I jump in with questions as they come in the chat or to wait to the end?
I think what I would do is maybe pause at like junctures to see if there are questions, like when I get to a reasonable point after going over some stuff, maybe.
That sounds
Okay.
good. Perfect. Yeah. And I'll monitor the chat though, so when you get to that pause, I can help you click the questions quickly for you.
Okay. All right. That sounds good. Thank you.
No problem.
How many
So
people are you expecting today?
we have 35 people registered.
Oh, okay. That's awesome. It's a good size group for questions.
Yes. And hopefully we've been going back and forth between webinar versus meeting format, because on the meeting format, people can unmute themselves and ask questions live, where the webinar, they can't. And so hopefully the meeting format, folks will be able to unmute themselves and ask their questions directly, but
Oh,
we
yeah,
will
that would be
also put
good.
them in the chat. But I'll start us out at 1 o'clock and I will introduce you and then hand it over to you.
Okay. Sounds good.
I think we have hit that 1 o'clock mark. Dr. Rudin, I'm going to go ahead and get us started. Hi, everyone. Thank you so much for being here. My name is Yolanda Fair with the Office of the Juvenile Defender. I'm one of the assistant juvenile defenders for the office. It is my pleasure today to introduce Dr. Maureen Reardon to everyone. She will speak from 1 to 2 about capacity evaluations and whether or not our clients need them, in particularly the ability to assist with the defense prong of that argument of the analysis. Dr. Reardon is one of only about 360 psychologists in the U.S. who have completed the rigorous credentialing and examination process of the Board of Certification in Forensic Psychology by the American Board of Professional Psychology. She has over 20 years of experience conducting assessments of justice-involved youth and adults addressing questions of criminal competency to stand trial, to waive Miranda, criminal responsibility, like insanity, diminished capacity, mens rea defense, risk of violent and sex offender recidivism, juvenile transfers, pre-sentence, and capital mitigation. She also conducts peer reviews and independent examinations in civil claims of personal and workplace injury. She has been qualified as an expert in many different times in both criminal and civil matters in multiple state and federal jurisdiction. She is committed to promoting the highest standards of practice in forensic psychology, not only in the quality of her work product, but also through active service and training activities. And she has offered seminars and workshops for mental health and legal professionals on a variety of topics, including forensic evaluations in capital cases, mental state defenses, involuntary treatment and commitment, diagnostics formulation, and expert consultation. She is the past president of the American Board of Forensic Psychology, and for 10 years served on the examination faculty for candidates seeking specialty board certification. And she is now the co-chair of the continuing education for the American Academy of Forensic Psychology. Dr. Rudin often answers a lot of questions for us, and I'm so thankful that she's here today to teach us about this important topic. So I'm going to turn it over to her. If you have questions, please feel free to put it in the chat, and I will monitor the chat. And Dr. Rudin will stop at certain times during her presentation to field questions.
Thank you so much, Ms. Fair. That was a very nice introduction. And thank you, of course, for inviting me to speak with you all today. You know, I welcome any opportunity that I'm given to sort of open the lines of communication between our two professions, because the more we speak the same language on some of these concepts that are pretty complicated, you know, the better it is in the service of the youth with whom we work. Let this get the slideshow going if I can. Hold on. We'll use the mouse. So in evaluations of capacity, of course, there's a legal standard, which is fleshed out, in my opinion, much better in the new law, but still needs to be broken down into measurable constructs. So in other words, there's some translation that goes on from the legal standard to how we assess these things and evaluate them in clinical terms. And it's hoped that this talk today will help you understand how we sort of think about these things and how you can elicit our testimony in a way that translates to the legal standard in the hearings. But in particular, I was asked to offer some guidance on the sorts of things that you can look for when determining whether or not to refer for an evaluation in the first place. Obviously, this is a very complicated question that involves some legal strategies and legal considerations, but from a clinical perspective, I'm going to point out some of the factors that we see that are causal, the things that cause impairments that can result in incapacity, including this sort of nebulous and new construct of, not a new construct, but new in the law, construct of developmental immaturity and what that means clinically, as well as some questions that you can ask or things you might be looking for in your young clients that might tip you off from a functional level, you know, where they may have impairments and where you might want to ask for an evaluation. I'm also going to talk about the referral process itself and the things that we need to know from you so that you get the questions answered that you need for these evaluations. You know, as you all know, the capacity to stand trial is essentially there to protect the rights of accused persons, accused youth, and ensure the fairness of the proceedings at all stages of the adjudicative process from the consequences of any impairments that might interfere with their ability to participate in those proceedings and make those decisions to defend themselves with your consult. I'm going to begin a little bit by talking about how we conceptualize as forensic psychologists clinically this notion of capacity to proceed. The leading scholar in our field on this, and he's also referenced in your juvenile defender manual, at least some editions of it. I haven't seen a recent edition, but he's a leading scholar in this area, and he essentially breaks it down into 5 separate considerations clinically. There's the functional, causal, interactive, conclusory, and prescriptive. Essentially, capacity to proceed is a functional question that basically asks whether or not the youth actually can or can't do the things that are relevant in participating in their defense as defined by the legal standard. In other words, it's an assessment of what the youth actually knows, what they actually understand and believe or can do that's relevant for competent participation in their case. The causal piece of this is, what is the thing about this child, be it their developmental immaturity, be it a mental disorder, be it a cognitive problem, that causes those functional impairments? That also has to be part of the assessment in this state, according to the statute. Interactive is a little bit different because we know that the nature of the charge, does not necessarily define, a charge is a charge is a charge, and a kid has to understand all of those things. But we do know that cases vary in terms of the complexity and the demands they place on the youth that you're working with. And so there is this sort of interactive component that happens in our evaluations where we're looking at whether the deficits that the youth may have may be more or less critical depending upon what the case demands may be. Are they going to have to testify, for example? Is that part of what you expect they're going to have to do? Is it likely to resolve in a plea bargain? We'll want to know those things so that we can assess this sort of interactive point. Because we may be able to assist the courts in weighing these factors by alerting them to deficits that may be more or less important depending upon what we know about the case. Also relevant here and a little bit more complicated are a lot more things impact a youth, as you know, than do adults. There's a lot of other figures, systems operating on them, various stressors, the role of caretakers, environmental stressors, when they're in secure custody, things like that. So we will be considering those implications, and particularly caretakers can have a really important role in the youth's life and in their legal situation. So that's part of that assessment. Obviously, conclusory is what it is. It's our opinion regarding those functional impairments and the causes thereof for this particular youth as it relates to the case. Of course, our opinions are essentially advisory, right? We're offering those to the court, and the judge is the ultimate decision maker as to whether or not the youth is incapable. And finally, something that's new, at least in North Carolina, but not new in terms of a construct in the literature, is this prescriptive notion, meaning that we are now required to provide recommendations for remediation in a way that considers the resources and time that is available for remediation. That's also specified in the statute. When you receive these court-ordered evaluations, we have been given this, I don't know if it's been updated yet, but we've been given this cover sheet that's supposed to accompany these evaluations. And I kind of wanted to translate this for you in terms of that 5-factor model. Your conclusory opinions at the top, what the cause of the impairment is second, and then the prescriptive. What if we think the youth is incapable, then what's necessary in order to get them capable? What's the least restrictive environment for those services, and how long do we think it's going to take? As I look at this, what I notice is missing is what are the functional impairments, which might be nice to have on this cover sheet, right? Like, what is it that the youth is struggling with? But essentially, this is what will accompany these reports. Now, as you know, for many years, North Carolina used the adult capacity standard for justice-involved youth in our state. But as we all know, kids are not just little adults. As compared to adults, the research suggests that if a strict adult standard was used, right, about 9 out of 10 kids ages 11 to 13 would be functioning the same as an incapable adult. And this was why, we, those of us who worked alongside legislators were writing this new law, set the age at 12, to make this sort of mandatory inquiry for kids who are 12 or under. I would have liked to see 13 or under, but at 12 is also good. But let's break this down here. This is the new law. But there's a lot of language in here that's really important, but it equates to that causal and functional analysis that I just spoke about. So the first thing is by reason of. This is causal. It actually says by reason of. What's causing this? That's the first part of our assessment. We are essentially looking at what are these things that might be going on with this youth that might be causing impairments, right? So that's the first thing. We have to establish that first, even before we can move on to the functional impairments. I want to spend, these things, mental disorder, intellectual disability, neurological disorder, maybe things that you're already familiar with, acquired brain injury, but developmental immaturity is a complex construct, and arguing a case that youth is incapable based on developmental immaturity is a tough one. So I kind of want to spend a little bit more time talking about how we conceptualize this concept and how you can elicit testimony from us to explain what is meant by developmental immaturity. The question, I guess, the obvious question is, aren't all youth immature? Like, are they all, developmentally immature? And the answer is yes, right? They are immature because they're not yet at the level of an adult, right? So they have not yet reached their neurobiological maturation, which happens about mid-20s. and there's still some various research about that, but it's certainly not 18 or 21, as the law might have us think. It's later than that, but it's incomplete. You know, they're immature because they haven't completed the process. But assessment of maturity is not just an age thing or even just a brain thing, which I'm not going to get into all the neuroscience about it. It's far more complicated than that. And this is because development itself is a complicated process that kids go through. For the first complication, development is nonlinear. It would be nice if, like, at age 12 you do this, age 13 you do this, and age 14 this is what we can expect, right? But it's nonlinear. It doesn't proceed in that direction. Spurts, delays, temporary regressions to an earlier immature level are the norm. We would expect kids to sometimes do better or worse depending on a lot of factors. The normal growth spurts that we see in development occur typically between the ages of 6 and 8, 10 and 12, and 14 and 16. That's where we see like a big burst of growth. But it's sensitive to contextual influences. It's also sensitive to development at an earlier point. So if something interferes with their development at age 10, it can have a big impact in terms of their subsequent development at age 12, 13, 14. Okay, and we'll talk about that in a moment. It's also idiosyncratic. And what I mean by that is development in one domain does not necessarily translate to development in another domain. So we've all had probably the experience of encountering a really bright, articulate kid who is just socially and emotionally, limited, right? So intelligence does not equate with maturity, for example. Development can also be context specific. So they may show varying levels of maturation and abilities at home than they do at school or in court, because there are different stressors and different expectations of them in those environments, which is why we need information from all those sources to sort of construct where the kid is at more broadly, right? Children are also inconsistent in their application of skills, and they vary from one day to the next, right? So it's also individual too. So you can't say that one 12-year-old is equal to another 12-year-old in terms of their development. Every kid's going to be different because obviously their life experiences are different. Their vulnerabilities are different. They might have different intelligence levels and things like that. So all this to say, two children can reach different levels of maturation despite similar paths. They might reach the same level of maturation by differing paths. And at any given age, youth can demonstrate variable functioning across domains. And this is why we call them moving targets, right? We might see them on one occasion, and that's how they present that day, but we need to construct how they are across the board when we're presenting this concept of developmental immaturity. But broad strokes, I'm not going to get into it too deeply here, but broad strokes, cognitively, we're going to expect some changes as kids developed, right? So as they are approaching adulthood, kids broadly should be increasing in their knowledge and vocabulary. They're going to school, they're learning new terms, things like that. They show better attention. They can track things, identify contradictions, errors, and keep log of that in real time. Can retain information better in real time. Their speed of processing improves. The biggest thing that we see is this notion that they go from sort of concrete to abstract reasoning. So here and now thinking, what have I had experience with? What do I know? What can I touch? To let me be able to think more broadly about things that I haven't experienced yet. Hypotheticals, metaphors, taking the perspective of not just my little world here, but also what you might think and what the judge might think, and how time works. Being able to see multiple sides of a situation instead of just the one piece of it. And of course, they're improving in their internal stop sign, like I like to call it. They're able to regulate themselves better and stop themselves from impulsive inclinations. Interpersonally, when kids are immature, right, they may be limited in their ability to respond to others and communicate properly. Well, obviously that has implications for the ability to assist prong and capacity. In terms of time, they really have a hard time early on, considering both long and short-term implications. They tend to weigh more heavily the short-term consequences and discount the longer range outcomes. So you'll see them say things, well, I just want a place so I could get out of secure custody, without thinking, oh my gosh, like this is going to have serious long-term implications. They're just focused on the here and now. Another thing that I've come to learn, I guess, through experience, and maybe you've had the same, is that when a kid grows up in an environment where those around them have little hope for longer term success, we sometimes see that kids have a foreshortened sense of their own future, right? So they may not even think of those things because in their lives that, people don't have a long life, right? I can't tell you the number of times where they say, well, like, I'll be 50, I'll be dead by then. And I'm like, oh my gosh, I'm 50. They don't understand that, like that people might live longer than 50 and you can still be a healthy, functioning adult at that age. So as we'll discuss later, these sorts of perspective taking things have an implication for your ability to assist and making decisions. They're also growing in their sense of autonomy, which is essentially their ability to think and behave in ways that are self-reliant and independent. If they're underdeveloped, what we see is that they have unstable personal preferences. And we see this in our kids. One day they like this, the next day they like this. They follow this trend and that trend. They have varying ways in which they weigh the opinions of others. And what we see for younger kids, well, I should say closer to mid-adolescence, we see more conformity to their peers. What their friends say carries far more weight than what the adults in their lives say. They're very swayed by that. The problem with this is that when you're going into a legal situation, you have to be able to make sound, independent decisions and stick with those decisions, right? Like they can't decide to plead guilty and enter that plea and then the next day change their mind because their buddy in secure custody told them that they needed to fight. But you'll see that in kids. All of these changes also relate to their perception of risk. Obviously, this has some relevance to their involvement in delinquency in the first place, right? This is the impulsivity. I'm going to take my chance because they don't really, they see fewer possible outcomes of risk-taking behavior and underestimate the likelihood of negative outcomes. The emphasis that we see is on the here and now, as I said. They're still developing this sense of foreseeing and anticipating consequences not yet experienced. And for many of our youth, this may be their first time in the system. So we, as attorneys and we as clinicians, often have to make those things really salient for them, like tell them what they're going to experience, make it really concrete so they can get it. Long-term outcomes are discounted in estimating risk, even up to the age of 17. In fact, risk-taking behavior peaks at 16 to 17 and then decline. So we see like really young youth take less risks than we see 15, 16-year-olds, right? They are more inclined. So that's what I mean. It's not a linear course. It can sometimes fluctuate. And as I said, they're developing their ability to take perspective. The reward systems become overactive, particularly around puberty, right? Whereas their stop sign is much slower to develop, right? So what we have is a very impulsive youth who make decisions based on emotional inclinations rather than thoughtful considerations of the consequences. And because these self-regulation systems are underdeveloped. As kids mature, there is a greater concern for the longer range outcomes, which, they need to consider in their legal situations. In broad strokes, age is related to incapacity to proceed in research as follows. Kids under 12 are highly likely to be functioning like incapable adults. Same is true of 1 in 3 youth between 11 and 13 and 1 in 5 youth, or 20% of kids 14 to 15. But remember, this is not normal, right? What is typical is what is based on aggregate estimates of large groups, right? But those aggregate group stats are often based on white middle-class children, right? And may not be applicable or generalizable to justice-involved youth. And by definition, almost, just the fact that they're involved in the system in the first place, they've already deviated in one way from the expected normative trajectory of adolescence. The stress of it, the nature of it, the fact that they're having to deal with all of these complex decision making that they wouldn't have in a normal developmental process. But I want to talk about this construct too, because youth are never just immature. Remember, I said all youth are immature, right? But they're never just immature. They're immature in relation to an identified comparison point. This is how we think about it. Thus far, we've spoken about only one kind, which is incomplete development. They're immature in a particular area because they're not yet at the level of a full-grown adult. right? Their brain is not a full-grown adult. Incomplete development of abilities in the absence of some other condition, a mental disorder or an intellectual impairment, may be sufficient to render incapable about 25% of youth, right? Statistically. More often, youth are immature in a particular area, be it cognitively, emotionally, or socially, because they're not at a level one might expect broadly for their age, right? They seem like an immature 12-year-old. They seem like a 14-year-old who's acting like a 12-year-old, right? That's the impression that they give to us. So we call this delayed development or disrupted development. Something happened that made their trajectory not follow the typical course, right? They're still going to become an adult one day. It will be completed someday, but it might be delayed or possibly disrupted or arrested development. And this can be due to mental disorders. It could be due to neurological disorders, intellectual disorders, or brain injury, right? Those things interact with age to disrupt development and impact their functioning in one or more ways. And even a very small deviation from normal development in a mentally compromised child can make big differences in terms of their demonstrated abilities cognitively, emotionally, or socially. So for example, 2/3 of youth with low IQs are incapable of low IQs, less than 89, are incapable. And if they're under 13, that becomes 80%. So there's this interaction that happens. And as we know, we got this mental disorder, neurological. This is much better fleshed out in the new law, but other things can impact development at one time or another. Stress can impact them, substance abuse, trauma, and many, many other things like family factors, access and quality of educational and cultural opportunities, their friends, like all of these things can interact with age and normative development to disrupt it or delay it, which can cause some regression. So these things also have to be taken into account. So my recommendation to you all, if you're going to refer based on causal factors alone, would be, if you see the kids, well, obviously, if they're 13 or younger, I know the law says 12, but 13 or younger would be my recommendation. If they have IEPs or BIPs in school, if there's a known trauma history, you might know that from DSS or their prior DSS involvement. If they're using drugs or alcohol, if there's some documented mental disorder in the record. So even before you talk to them, you might have some of this information from mom or other sources, right? That might tip you off that a capacity evaluation may be needed. And I'm going to add possible, right? Because we know that these things do not equate with capacity. You can be 12 and capable. You can have an IEP in school and be capable. It's not enough to be young or have a mental condition. And I would just add that just because it's listed somewhere in their record doesn't mean it necessarily impairs their capacity. Like they could have a reading disorder. It's a disorder, I get that, but it might not impact capacity. But it also doesn't mean it's an accurate diagnosis. We see a lot of kids misdiagnosed or having a laundry list of diagnoses, and you're like, oh my gosh, this kid's got to be so impaired. He's got 15 diagnoses. It's probably more accurate that it's one and no one did a very careful differential of the kid. That's what we do when we do an evaluation. We are trying to isolate what is the impairment here? What is the causal factor that may be resulting in these impairments, and really narrow it down because we need to know how to treat it if the child is in need of remediation. But as you know, capacity is a functional analysis. So before I get to the functional analysis and things that you can look for in terms of their functioning, pausing here to see if there are any questions about the causal elements of incapacity.
No current questions in the chat.
Okay. So it's either like totally clear or completely unclear. we'll see. All right. So getting to the functional piece. This is also outlined in the statute, right? These are the functions that the kid has to do in order to be capable. This is essentially the Dusky standard. It's essentially the same as the adult standard, right? The only thing that's changed really is the addition of the word juvenile, right? In the standard. Nothing's really changed here in terms of what's expected, because there's certain fundamental things that you have to do to ensure a fair proceeding. But we as psychologists break down these things into abilities that we can measure and assess. So I'm going to talk about how we conceptualize them, and then I'm going to talk about how you can maybe do your own mini assessments with your kid to see if these impairments exist, okay? We break it down into things that are foundational competence and what's called decisional competence, right? That's the way our mindsets work. The law breaks it down almost into three prongs: understanding the nature and object of the proceedings, a rational understanding of your own situation in reference to the proceeding, and ability to assist in one's defense in a reasonable and rational manner, right? For us, understanding the nature and object of the proceedings becomes a factual knowledge test, essentially. Do they know the legal concepts? I'll get into that in a moment. Own situation in reference to the proceedings is how they're able to say, okay, I know this about these legal terms. How does that affect me in my situation? Can they apply it? What do they believe about their situation? And often forgotten in evaluations of adults and youth that I see is this notion of decisional competence. They focus more on the communication, the ability to convey information, to assist in their defense. They forget about the notion they also have to make decisions. And how do they make decisions? And I think that's the part that's often overlooked in juvenile capacity evaluations, but I have some ideas about how you can assess that in your kid. I'm not going to spend a lot of time too much on the foundational competence piece because it's pretty straightforward. This is the easy part of the assessment, right? This is us trying to get a sense of the youth's understanding of the nature of the allegations. They don't have to know the exact charge, what it's called, but they do need to have a general sense of what's being alleged. They have to know the range and nature of allowable dispositions, right? That's where you come in and telling us what those dispositions are. Don't assume that we know that. We might not know what level of supervision they're at based on their prior record. This is the roles of courtroom players. What we see sometimes is a very concrete understanding of those things. Prosecutor against me, attorney helps me. But it's far more complicated than that. We need them to understand more broadly, what does that help mean? And being able to differentiate like the help of an attorney versus the help of a therapist or a school teacher. Some kids don't understand that difference and why your roles are different. Generally, and of course, the adversarial nature of the proceeding, essentially the entire process from arraignment to disposition. We're assessing their knowledge of all the concepts and things they need to know, right? When adults don't grasp this information, it's mostly because they can't grasp it. Like if we see they don't have that knowledge, it's probably because they have an intellectual disorder or brain injury or something that means that that's not acquired or has never been acquired. But for kids, it's often due to actual deficits due to inexperience, right? They haven't been in the system before. And it may be that they have the capacity, but just haven't been exposed to that information yet. So we're assessing their capacity to learn. And I would suggest that you do that as well, right? They may come in and be clueless. A lot of kids are going to be clueless about all of this stuff. It's all brand new. But can they get it from you? Can they learn from you is the real pivotal question when making the referral for the evaluation. So again, I have some research notes here. Remember broad strokes. I'm just going to keep pushing that. These are not hard and fast rules. But where we see weaknesses are complex concepts like defense counsel, presumption of innocence, plea bargain, and their procedural protections as an accused person. So what you can do to gauge this is, and you're probably already doing this, right? You're breaking up anything complex into simple, developmentally appropriate language. You're hopefully trying to avoid hypotheticals, particularly for the young kids. But then take a moment to say, now tell me what I just told you using your own words. Don't try to be, don't just say what I just said. Just tell me in your own words what you understood. Do that immediately. Wait 15 minutes, do it again, and then wait days or even weeks to see if they can retain that information, right? If they demonstrate that they can, then this is not a problem for them, right? If they're able to learn stuff, if they can learn a few things from you, they'll be able to learn other things from you. You don't have to do every single concept. If they're not, maybe they can parrot it back real quick, but then 15 minutes later, they've forgotten it. Well, then you know that you might need to refer on this basis. Appreciation, as I said, is what a youth believes about what they understand, right? So they have this factual knowledge. What do they believe about it, and how do they apply it to their current legal circumstances? And like this rational understanding piece, right? In adults, we're usually talking about psychosis, right? There's some irrational belief, some delusion or something like that that interferes with this piece, their rational understanding. But in juveniles, this will most often be rooted in those normal developmental processes that they're still undergoing. They like the concrete thinking, their immature assumptions, confusions, or even some erroneous beliefs about what these things are. So like I said, a youth may be able to say an attorney helps you, but does not know what that help actually consists of. They may not appreciate that it's hard for them to grasp like why you would be an advocate for them. Like, I know that sounds very strange, but they might have a hard time understanding like why you might even set aside your own ideas of about how best to handle the case and defer to their, like how they think they want to proceed. Like, why would you do that? Like, you're the adult, right? That whole notion of this like role. I mean, the whole courtroom, right? They're the only kid, and there's like all these adults. Um, that's a whole other thing for them to be able to appreciate why you might be willing to help them, even if that help is maybe against what their parents' wishes are, or contrary to normal social distinctions. I hear defense attorneys help, but only if you didn't do the crime. You can plead not guilty if you actually did the crime. You can't do that because it's lying and you can't lie in court, period. Hard stop. And that's like just a very concrete understanding and means that they don't really grasp the notion of evidence, presumption of innocence, and that sort of thing. This is one I hear all the time. I could be in juvenile detention a really long time, like when my mom sends me to my room for the whole weekend, right? That's that time perspective. Things seem much longer when you're a kid, right? And they don't have like this notion of like what a year really means for them. I even assess this by just asking them, well, if you get like 2 years on supervision, how old are you going to be when that's over? And sometimes they'll be like, I don't know, like 12 and a half, and they'll be 12. And you're like, no, that's like, you got to add 2 years. You're going to be in middle school. Like, do you get that? You're going to be older when this is over. Again, the research note. So these are the questions that you'll ask. They're going to be why and how questions, right? And these are questions I might ask. Can they put the allegations in their case in relative standing? Do they get that like murder is more serious and why, or not obviously if they're charged with murder, but like, do they get like other crimes that would be less serious? Do they know why it would be a problem if they didn't talk to you? What could be the consequences of that? How is turning down a plea offer like taking a chance? What do you think the worst thing the court could do to you? And they might say detention, right? And then you might say, why is that the worst thing? Very recently, I had a 12-year-old, and it was funny, not funny, but an indication of like the development issue is I said, well, what's the worst punishment your mom ever gave you? And it was something like writing sentences, right? Like I had to write a bunch of sentences, and if my penmanship was bad, I'd have to write it again. I said, okay, what's the worst the court can do to you in this situation? He's like, well, I don't know. Like maybe I guess I could go to detention or like to, juvie. I'll go to juvie. I said, well, what would you prefer? Would you rather get the sentences or the juvie? He's like, oh, the juvie. One time it took me 3 days to finish those sentences. And I said, oh my goodness, like, you might be in juvie for months, right? And he's like, and I said, well, tell me some other reasons. Well, if I go to juvie, I won't have to do the chores. I have a lot of chores at home. And I'm like, you're going to have chores. And like not having to go to school. And I'm like, oh, you're going to have to go to school too. Like, so all these things that they can't envision because they haven't experienced it yet. Now, what I did with that kid is I explained and made salient what those things are. I made it concrete for him. Actually, you are going to have to do chores. Actually, this might be the case. He's like, oh, actually, maybe I'd choose the sentences, right? So he showed the capacity for reflection, but his first inclination would be to go with something, like far more serious because he's focused on these misperceptions rooted in this, lower development, right? Hope I'm doing good on time. We're working through it. Okay, we're at assisting, which is the meat of it. I'm breaking this down into 3 actual components, right? They have to have the ability to consult and assist counsel in their defense in broad strokes. So the requisite skills, many of which are listed in the statute, are they have to be able to meaningfully aid and develop and present a defense. They have to communicate with you about matters relevant to the case in a manner that you can understand. They have to be able to identify sources of relevant evidence and witnesses, reasons why they might have to confront opposing witnesses. They have to be able to communicate those things. And so like, that's a lot of things, right? They have to be able to identify what's relevant. That's part one. Do they even know what's relevant? Because you may not know what's relevant. They were the person there potentially that can tell you what happened. And if they don't know what to tell you and it's not written down in police reports, well, how are you going to know this information? They obviously have to be able to track and comprehend testimony of other witnesses so that they can maybe inform you that that person's lying and things like that. And they're not just like in, daydream land, not paying attention to what is being said. And they also have to be able to provide testimony with relevance, coherence, and independence of judgment. So all of these things, cognitive maturity, emotional maturity, and psychosocial maturity, all feed into this. They're just learning some of the terms, right, and being able to communicate. And we need to make sure that they can verbally communicate in the lexicon of a legal context, right? Their attention and tracking skills are still in development. Their ability to emotionally regulate themselves. I mean, court is stressful, right? They have to be able to manage that. So that's part of this assessment. What we see is younger kids provide distorted information when they're under pressure. We know that, like just from confessions and things that we see that they do in interrogation situations. They withhold information from you, fear it will be used against them. So again, that's this whole ability to understand that you're an advocate for them. You want to know everything, that you need to know everything, even if it's like maybe not good stuff about them, so that you can help them. Most of them actually view their role, because in general in life, their role is to show up and behave well, right? Like that's all they're required to do. The notion that they would actually have to help you is a concept that they don't get a lot of the time. They may have trouble building rapport with adults and strangers, which you will be at the outset. And again, this notion of perceived autonomy. Do they really understand that they have a choice about how to proceed in their case? So this is assessed essentially through behavioral observations, answers to questions regarding the offense, how accurate those things are, the flow and logic of their communication. And again, what we see is, these aggregate stats based on age, but youth with mental conditions characterized by hostility and excitation, which you might imagine, ADHD, disruptive mood dysregulation disorder, as well as those who have problems socially or with anxiety, may be especially vulnerable to deficits in this area, just in general. That's not even talking about their ability to work with you, right? Now, the law doesn't promise a perfect match, right, between a client and their attorney. That's not part of capacity. It's not, they have to get along with you. They have to be able to get along with an attorney more broadly. But I am assessing how they get along with you, right? Because you're their assigned attorney. So I do want to know how it's going. So I would suggest, and you're probably, again, these are suggestions, but you're already doing them, no doubt, is that you're taking time to establish that rapport and that working relationship and getting to know your client by asking questions. And you don't start right off with the crime, right? Like most of the time you're at, how was your day? Like, what are you doing in school? Like, tell me about your friends. You're making those efforts to get to know them as a person, right? So I expect you're doing this. But I would say, like, add certain questions, like, what do you expect from me? What do you think that I am expecting of you to do? How do you think I can best help you? Is there anything you're worried about telling me? That's actually a funny question, because a lot of kids will just tell you what they're worried about telling you when you ask that question. I add this other thing because there's been this lived and vicarious legal experiences, because there's been a growing body of literature on this. And I think it's important to inquire what they've been through in the legal system, and maybe what they've heard from friends, family, relatives who have also been in the system. Because you need to take time to understand what they think the legal system is. That's part of their beliefs, and correct any of those misperceptions, they're getting feedback from a lot of people. And unfortunately, some of them have parents who have been involved in the legal system, who see you guys as public pretenders. I've even heard kids say that term, and obviously they didn't come up with that. They heard that. When you're meeting with them, do they defer to their parent to answer all the questions? I'll be doing an evaluation. I'll ask them a question. They might say, oh, you're going to have to ask my mom about that. And I have to say, I'm asking you about that. Like, what do you think? But you'll see that. You'll see that when you're meeting with them, that they're deferring a lot to their parent. And of course, and I'm sure you're doing this too, make time to meet with them without their parent. You will see a very different child a lot of the time. Are they shutting down when they're talking to you? And is that context specific? Like, do they shut down when you ask about certain things? That might be notable. That might point to indications of trauma or maybe not wanting to talk about the offense conduct. You want to get an account of their personal history and allegations, right? You need that. You need the allegations. But what I'm assessing when I ask for things about their personal history, I know I'm not going to get an accurate, fully accurate personal history from them. I'm going to fill in the details of their birth and development through their parents and other things. I'm looking to see, can they communicate logically? Like, does it follow a sequence? Is it sufficiently detailed? Can they tell things in order? And how long ago things happened? And with regard to the allegations, does that follow a logical sequence? Is it a story of what happened? Or is it a bunch of like piecemeal information? Can they identify evidence that might hurt them or help them, or mixed, right? That's that abstract reasoning. Do I have any questions yet before I moved on to reasoned decisions? This is the last little piece of the assisting puzzle.
Here's one question. So Liana asked, so it seems to be a good practice to make a referral for a capacity eval if one or more of those causal factors exist, or should that be coupled with our own concerns, read the juvenile's understanding of the process?
Yes, it's better if there's both, right? But the initial tip-off that I might need an evaluation are the identification of those causal factors. And this functional piece is all these things I'm talking about now that you will notice when you start asking these questions that are in the slideshow to elicit these functional abilities. And then I'm going to talk about what we want to hear from you, which is all of those things in your referral to us. Was a really good question. So it's both, I would say, or one or the other, right? You might not know what's, this kid just strikes me as there's something not right about him, but like I looked in his record, he doesn't have an IEP, when I meet with him, it just seems like he's not getting it. Good, that's a functional, right? Or it's like, there's an IEP here. I see that in the record. I'm not sure what it means, but like, let me go ahead and make the referral, right? Like, so it could be both, or he has an IEP and it seems like these are the deficits he's showing to me. He can't read and like, I'm seeing that he's having trouble when I meet with him. Making reasoned decisions is a tough one to assess, and the one that kids struggle with the most, because this is the process, the higher level cognitive process that's still very much in development for youth. They have, again, difficulties considering the relative strength of evidence when making important decisions to waive their rights, right? Like, do they weigh it? Not all pieces of evidence are equal, right? They also, as I said, have trouble weighing the long-term consequence against these short-term gains that they might get. So they're impulsive in their decision. They make decisions based on emotional inclinations rather than thoughtful considerations of the consequences. And that's oftentimes because they just can't even envision them. They don't even know what they are. And it requires their ability to, well, that's the next one, identify these alternative consequences, estimating probability of things happening. This is where you come in, like the likelihood that they will be acquitted, right? Or that they will be found not responsible versus the likelihood, hey, there's a lot of evidence here. We might really need to consider, how we want to handle this. Because they're going to weigh it based on the desirability of the outcome. Like, what's in it for me? They won't necessarily be able to say like, wow, this evidence is really stacked up against me. They're thinking, oh, I could win. They don't understand that there's a whole process in that winning and prevailing. So we get at this in terms of how kids make decisions. How I assess this is I will ask the parents or caretaker how a youth makes an important decision, or if they seek advice from them, how well they heed the advice of their parent, right? Are they more inclined to listen to their peers when making decisions, or do they listen to you? Not about legal situation. I'll ask about any decision, having dinner, like what to eat for dinner, which is a huge discussion in my house every single night. The youth's description of how they made an important decision recently, not a legal one, just any decision that they had to make. you might present them hypothetical decisions and ask them how to explain how and why they made that decision. I'll get into that in just a moment. Oops, maybe I'm getting into it earlier. So when you're asking this, like if you're going to ask them about, potential plea bargains, for example, you might vary the amount of punishment that they're facing. Hey, you might have to spend, a week in detention, but then you'll be on supervision for this long. Okay, well, what if it was a month in detention and then supervision for this long? A question that I will often ask for the hypothetical scenario is like, imagine that you and your friend got in trouble. And at the same time, and like really like you guys were both in trouble for stealing a candy bar from a store, but he was the one who actually put it in his pocket and walked out. If your attorney wanted to know if anyone else was involved, would you tell on your friend? Like a lot of kids won't. They'll say, no, man, they'll even say things like, I'm not a snitch. I'm not going to tattletale. Well, why do you think your attorney might want to know that information? Even they don't get, like, they're helping their defense, but they also have these beliefs and ideas that they also simultaneously should be protecting their friend. And as an attorney, you need to know that information. And if that's how they're making decisions based on, oh, I'm not a snitch, emphasizing peers, as opposed to their own autonomous decision-making in their defense to help themselves, well, you need to know that that is their inclination. So that's a question I might ask of them. And doing the hypothetical scenarios when you're asking about time in detention or supervision, you need to make sure that you have already made salient for them what supervision means, right? Is that going to involve electronic monitoring? What does that mean? Is it going to involve, drug testing if that's required, mental health care? You got to go to school, and actually come home at 9 o'clock at night. Like, make it real salient, because to them, they might not even have a real understanding of what supervision is. So again, bringing the abstract into the concrete, particularly for younger kids. And then there's the contextual considerations. I'm kind of running short on time here. But I think what I want to speak about here is what are the specific case demands? Because if you know this is going to be far more complicated case, you're going to need to spend more time gathering information, but also letting your expert know, hey, I'm going to need this kid to be able to testify here. This is a self-defense sort of situation, or these proceedings are going to go on for a while. Like if we take this, it's going to be complex. There's going to be a lot of witnesses. You want to let your expert know about any other stressors that are working on this kid that you already know about, or collateral consequences, like for kids with sex offenses, were they removed from their home? Is reunification even on the table? Just different things like that could be collateral consequences of an adjudication in their case. And then integration of caretakers and the legal guardian. Now, this is a tricky one, right? Because we know some caretakers and parents are very well-meaning and want to advise their kids and have a good grasp of the legal system and like advise them in ways that protect their rights. But actually the research shows quite the opposite, that many of the parents that we deal with, particularly for kids who have a long history of behavioral problems, are relieved that their kid is in the system. About time they're going to get consequences for the hell they've been raising at home all these years, running away and doing these things. I'm finally going to get help. I haven't had the resource to help, and now DJJ can help. They don't, with that mindset, you're going to want your kid to take responsibility and go through the system, not really realizing the implications that has for the child moving on, that each case, kind of accumulates over time. So knowing more about the caretaker and providing that information to your expert allows us to assess where they're getting some of this information from. And think about this, they may be getting mixed messages. They're hearing from you, well, we're going to defend against this. This is how I'm advocating for you. While they're home, their parent is saying all these other messages, right? So what you may be seeing when they shut down, when they speak with you, may not be an incapacity, but just confusion because of all this mixed messages that they're getting. And so knowing what those things are is very helpful for us when we're evaluating them. So some may be supportive and helpful, others interfere. Regardless, when you're making the referral, we do need to know who the legal guardian is. Because if it's a privately retained assessment, ethically, we have to get the consent of the adult to go forward with the evaluation. You can't do sort of, it's not really a procedure, but a psychological assessment of a child without their parents' consent. And you may be thinking, well, I ordered it, like I want it, I got the ex parte order. They still have decision making, and we still have to get consent from a capable party, an assent from the kid, right? Like we want to, we want them to cooperate. Now, court-ordered evaluations are different. Those do proceed regardless of whether or not the parent gives that consent, but that is a difference. Regardless, I'm going to want to know who the caretaker is, because they're going to be the best informant, presumably, of background information, development early on, sort of the lay of the land of family history, things that kids just don't know. Like they're not told if grandpa had schizophrenia. Like they know grandpa might be a little odd, but they don't have the family history, right? When you're referring for the evaluation, you have to make a decision from the outset, private or court ordered, right? Like, am I going to get a privately retained assessment, or am I just going to go through this process of court order? There are some, at this point, and hoping that it improves, but there are some issues around funding for court ordered assessments. And I will say, as someone in private practice, the time constraints of these court ordered evaluations make these almost not possible in my practice. Like I wouldn't have time to do a court ordered evaluation because there's very strict timelines on when these things need to be done. And in my experience, gathering the records that you need in the first place sometimes takes as long as that court ordered time frame. So my opinions would be very limited, and I don't like to work that way, right? Private obviously has its benefits in that you have some control over the information that gets released to all parties, right? But what we need to know essentially gets at the earlier question. What was it that you know about the child historically, these causal factors, or what have you observed in your dealings with them? Or I've dealt with mom, and oh my gosh, this is going to be really complicated. What prompted you to request the evaluation? We want that first and foremost, right? Because those are the things we're going to emphasize in our assessment to try to answer your questions. And it's, I sometimes will send an attorney questionnaire that elicits this information from you. Tell me what, right, fill it out. What were the things that made you concerned about this kid? And maybe the concern is he's 11, or he's got an IEP. I don't know. I just want to make sure he understands. I also appreciate when you all let me know that capacity isn't the only question you have, right? Because oftentimes we may be looking at capacity issues, but maybe your real question is disposition, right? So just be upfront about that, because I will say that I'm fine to do those things sort of sequentially. Like I'll make sure the kid is capable, and then we can move on to other questions. But some evaluators won't do that. They would prefer only answer one question. And so if your real question is more complicated, make sure your expert has that information in advance. So then you're not trying to scramble for a disposition expert when this person was fully incapacitated. Does that make sense? Also, informing the evaluator of any unique case circumstances, again, what the possible dispositions are, the demands of the case, and these collateral consequences. And the most important thing for us to do our job effectively and provide you the information you need in the report is to gather and provide as much collateral data in advance of the assessment as possible. And I know this is really challenging for some agencies, but the reason why this is important gets back to the notion that kids are moving targets, right? I'm only seeing them on one occasion, maybe two, if I'm lucky, if the funding is there, right? But most of these court-ordered evaluations, it's going to be a one-time thing. And so one way we compensate for that, because they may present one way for me in the room, but one way I compensate for that is to gather that collateral history, which allows me to sort of put into context what I'm seeing today on this single occasion with what other people see in other contexts and at other times. So that I can interpret my findings in light of what I know about their development more broadly. Okay. And I know sometimes I've heard like, I don't want to give you this. It looks really bad, right? Like you don't want to send the disciplinary reports about the kid, right? I would say that, the facts or data on which my opinion is based is not necessarily independently admissible. That's number one. And number two, the law is much more explicit than even the adult standard in saying incriminating information is not to be included in the report, right? So, you know, if you get a court-ordered evaluation where that is in there, I mean, that would be for, I mean, legally, I would handle that, right? Like that's something that you would want redacted from the report, right? And it should not be brought up in testimony. It shouldn't be there in the first place, but I'd be lying if I said I didn't see forensic reports with that information in it. And lastly, and something I know the least about, and something we all know the least about, is this remediation piece. If the court finds that juvenile is incapable of proceeding, it must also determine if the juvenile is likely to regain or attain capacity through remediation services. And these services are based on the recommendations from the forensic evaluation. So if I'm opining that the youth is incapable, I then also have to include, and this is what he needs to become capable. And this is how long I think it's going to take, right? And the judge is going to make some determinations about what those services are going to be in light of the statutory limitations on how long you get to implement those services. Currently, DJJ is responsible for arranging the remediation services. The problem is youth are incapable to do a much wider range of mental disorders compared to adults. And what I mean is like ADHD in a kid versus ADHD in an adult is unlikely to make them not capable. Depression, post-traumatic stress disorder, anxiety in an adult, it's probably not going to rise to the level of disease or defect that would make them not capable. But those same conditions very well may interfere with maturation in a way that makes this youth not capable. Okay. So the problem also is that like some of the conditions that the kids have that are making them not capable don't rise to inpatient psychiatric hospitalization like an adult might. So that's not part of it. We're trying to find services in the community. Some disorders are responsive to medication, but some are not. You know, no psychoeducation that you provide or medication is going to fix a communication disorder, for example. The more complicated question is therapeutic interventions for kids involve lots of systems. Maybe it's not just psychoeducation, but you have to integrate the family, the school. And then there's the access piece. So psychoeducation may be easy to provide, but who pays for the medications? Who forces that process? All those questions are still sort of unanswered in the new law. And youth who are incapable due to immaturity, just immaturity, require further development, not treatment, right? And so for young youth, that could take years. And it's time. Time is the remediation. And so sometimes I'm offering that opinion. This kid needs to develop more, right? Sometimes it's developed with treatment. But when we're making these recommendations, the judge has other considerations like protection to the public, the seriousness of the offense that won't necessarily be part of this remediation recommendation. And that's where you come in arguing what the least restrictive environment ought to be. This is an article by Jackie Green at UNC School of Government, which is an excellent resource. So I'm just adding that there. But there are still a lot of kinks that need to be worked out with this remediation system. I know I came very close to the time here, so I'll stay for 5 minutes additional for any other questions. And of course, offline, I'm always here to answer your questions or consult. And even if you're just not sure if you should get an evaluation, I don't need to be paid to talk to you to say, hey, this does sound like something you might want to pursue. And if I can't do it, I'll give you a referral to someone who can. So thank you for your attention. And I'll answer any questions that there might be.
Thank you so much, Dr. Reardon. There's no current questions in the chat, but I invite anybody to unmute if you have any questions, or please put some in the chat. Oh, I think Star has her hand raised.
Thank you so much for this presentation. It's been amazing. I'm Star Ward, do juvenile work out of Guilford County.
Okay.
We are having a major problem finding people to do our evaluations. The person that we had before, she's no longer qualified, can't do them. I was recommended to another person at Trillium Healthcare, and then I found out this week she's not able to do them. She sent me a link, I guess maybe to AOC link or something that had a couple of people that may be able to do them throughout the state, but there's nobody in Guilford County or even close. So I just wanted to see, like, how are we going to find people to do our evaluations? I've got two that have been out for months.
Yeah, that's a really good question and also a really big problem. So I presently serve on the Juvenile Credentialing Committee through DHHS, and it is not a hard process, but according to law, that DHHS is responsible for credentialing qualified providers, and there are specific things that they need to have in order to be credentialed under the new law. They have to be able to test, for example. I mean, it's a far more comprehensive evaluation than the screenings that we have typically done for juveniles in the community, like through the local mental health centers. Currently, there are 30 people on that list, which sounds great, except I will say that many of them don't travel. Several of them are tied to our state agencies, like the hospitals, and therefore can't do community evaluations. That would be a conflict of interest. So we have started broadening our reach to adjacent states, people who are licensed under SIPACT, which allows for certain days of practice. But even still, it is a serious problem. And the other issue is many of us who are also on the list, I'm on the list, but as I said, I can't fit them in to my practice. And so I believe my understanding is a juvenile court counselor is supposed to be the one accessing this list and identifying the experts. And there is, you know, a request that you first confirm the availability, like don't just willy-nilly, because some people were getting court orders. You're doing this assessment without inquiring if the person was even available. So yes, it is a serious problem. And unfortunately, I think the best way at this juncture to handle that, if you can't find an expert from that list, would be, you know, the state hospital evaluations. It would have to go to CRH, which is not ideal, but for court ordered. Now, the alternative, of course, is getting a privately retained assessment, which gives more time to the evaluator to do the evaluation and gives you some more control over it. And also, there may be more experts to choose from.
So to follow up on that, one of my clients is in DSS custody, so either in a foster home, lately he's been running away and is in detention. So that's an issue. And then, I mean, I have other kids. My other one that needs evaluation is a sex-specific type of charge. I don't know if our judges are going to send them to Central Regional. Is that what you're saying about a state hospital?
Yeah, I mean, they're part of the court-ordered evaluation process. And I think the idea was to not make kids have to go to the hospital in the first place to have these evaluations, that we could do them in the community and have court-ordered evaluations that way. But just due to the limited availability, it's going to be a long wait list. And I will say that another unspoken, perhaps, hurdle is funding for these evaluations. The law specifies that the local mental health agencies pay experts like me to do these evaluations. AOC is refusing to pay. It's like, who pays? Who pays for these? And that's a real problem, because if you're working as an expert privately and you don't know if you're going to get paid, that's a real problem. IDS doesn't pay because these are not IDS cases. There is a loophole form, J485 and 486, that some have been able to utilize to get paid. So if that's the complaint that the person has, I can't take this because the funding issue, say that this 485 and 486 is available. And some people have been paid that way, but I don't have any really great recommendations for you other than maybe seeking a private evaluation.
Okay. Okay, because we're all kind of at a loss here. So I mean, some of
Yeah.
these evaluations have been kicking around 4 to 6 months. Last time I had a kid sent to Central Regional, it took a little over a year to get that
Yeah.
back.
And in that
So, I
time, you
mean,
could get the private evaluation done, more than likely.
is that like going in and getting like ex parte funds,
Yes.
things like that?
Mhm.
Okay. And I assume that I could probably go through that list or contact the juvenile defender's office to find a list of people who might be willing. Okay, I see a yes. Okay, I'm going to be emailing you.
Good luck.
Okay, thank you so much. I appreciate you answering my question. Thank you again.
And I think that may be the last question. I don't see any additional ones in the chat, but I just want to thank you so much for being here and taking the time on a Friday to teach us about capacity and just doing a deep dive into the different factors. I think that was very helpful for me, and I know for all of the defenders on this call as well. Dr. Roden has her information on the slide. We will also send that out in her PowerPoint and a follow-up email. Thank you all so much for attending again, and thank you very much, Dr. Roden.
Thank you very much for having me. Take care. Have a good
Thank
weekend,
you.
everyone.
Have a good weekend.